Listen, listen, listen. Listen to me, my children, and you shall hear of the daylight ride of William Wagener down to the Ronald Reagan Federal Courthouse. We watched federal judge in the 9th, David O. Carter, said, nobody's going to go to jail. And he said, this is not a frivolous case. That was amazing. Taking my hat off for you people that tuned in tonight. Federal judge said this case brought by Billy Renee Powers was going to be heard. But before we got there, he went through first call, second call, third call, then took a break, made a phone call, came back, and finally, for the first time, after third call and a break, called the case of B of A, Wells Fargo, Quality Loan Servicing, whatever the other fourth one was, versus Billy Renee Powers, or Billy Renee Powers versus all the banksters, or I like to call them bank-gangsters, because they really are bank-gangsters. And if you understood that the bank is not lending you money, you're not getting a loan. They didn't take money out of the bank's account and give it to you, but you created the money when you signed all those documents you did not understand. There's a method to their madness. And the main thing is they don't want you to ever understand how the banking system really works. It's not what you think. There isn't some little clerk mole sitting in the corner of the bank who registers your loan and every month strikes off you made a payment, and a year later you made a payment for 30 years. They securitize illegally, unlawfully, those things and send them off to New York to be bundled with other loans and sold in packages of hundreds or thousands of mortgage loans, most of which they know are going to be defaulted on. So Billy Renee Powers, this grandmother from the corner of Orange County and Riverside County, who was forcibly evicted from her own property through the scams of what I call the bank-gangsters, she went to court. And to our amazement, David O. Carter said, okay, the bank's claiming this is a frivolous case. I say, it's not a frivolous case. We're going to get to the merits of this case. And Billy, in her motion, said, I also want criminal prosecution against the bank's attorneys. And the judge said, no, I'm not going to call the U.S. Attorney's Office and ask them to prosecute you. So nobody's going to jail, but it's not a frivolous case. So her attorney didn't show up for a while. And we think the judge, David O. Carter, who's been on the bench there for, I think, 20 years, he's presiding judge of the Ronald Reagan Federal Courthouse, I believe, right now, this year. He said, I'm going to make a phone call. We think that phone call was to her attorney, Swan. Angela Swan, I believe is her name. And he was telling her, get your butt into this court. You signed on to this case a week or so ago. You're not going to drop out and be a no-show and embarrass the Bar Association and embarrass the federal court by simply proving all these people in the lobby are right, saying it's nothing but a kangaroo court, kangaroo justice. The judges and the attorneys hop over justice to effect injustice, pretending under color of law all the time that what's happening in those courtrooms is justice. Judge Carter, we believe, made that call. And sure enough, about 20 minutes later, after he called and Renee Powers had started to do her spiel and answer some questions, and the judge took time, and I labored at watching all the cases prior to this. He took time to start recounting this case, where it had been, where it started, what motions, and now we're at this point. I think he was killing time to give that attorney that absolutely did not want to show up in the court because allegedly she was threatened by somebody who got the threat message from the bank-gangsters crowd. We're not saying it was Steve Daly or any specific attorney, but somebody, we believe, threatened her with loss of her license, and then after that, a lot of bad things would happen to that attorney who signed on to take Billy Renee Powers' case. So finally, her attorney, Angela Swan, I believe was her name, shows up in court, poorly dressed, hair pulled back like she just matted it, and no makeup that you could see, Most people in the gallery, the women in the gallery were far better dressed for court than her attorney was. It looked like she just rolled out of bed and didn't want to come, and there she was. And she said almost nothing. She said, "I'm Angela Swan. I represent the plaintiff here, Billy Renee Powers." And she shut her mouth. And the judge had to pry her to get her to say anything at all. Finally, the judge said, "Well, how about if we let your client speak?" Now, if you've been to court very often, you know they don't want the client to speak. The fact that you hire an attorney is an admission that you're incompetent. You cannot speak for yourself, especially if they haul you in court in all caps, your name in all capital letters like a corporation. They're treating you like a corporation or a corpse, a dead entity. Since you're dead or incompetent, they have an attorney speak for you. So it's extremely rare you see a judge actually invite the litigant to speak while their attorney's sitting right next to her, and their attorney refused to read what the prior week, this was a Monday earlier this month, attorney and her had worked out in the attorney's office. And then something happened over the weekend and she got cold feet. And early that morning she filed a motion, we're told, I haven't authenticated it, to be removed from the case. And the judge denied it. Then he made that call and said, we believe he made that call and said, get your butt in here. You're not going to embarrass this court. So she showed up. Anyway, he invited her and he said, would you mind if we let your client, Billy Renee Powers, speak? So she did. Now, last I talked to Billy Renee Powers, she had ordered the court record, and the court record she got, the court reporter's record went right up to the last syllable before Billy Renee Powers read her statement. And it was a powerful statement. So powerful, the audience was applauding. And you never see an audience applaud in a courtroom. The judges don't like that. Whether it's a federal judge or state judge, you're not supposed to applaud. It's not a wrestling match or a tennis game, or a basketball game. The Judge Carter was shocked. He was like, what? People are applauding in my court because Billy Renee read this powerful statement? So at the end of it, he said, this is not a frivolous case, and I'm going to take some time to meditate and think about it. And then he said some other spurious things about, isn't it sad so many people lost their homes in the credit crunch of 2008. All that was to deflect from the focus Billy Renee Powers had put on the fact that these are foreign banks who are illegally making loans in the 50 states. And she cited the congressional law and the Supreme Court ruling that upheld her statement. We left court. I argued with the judge after they'd done this case. I couldn't keep my mouth shut. Finally said, excuse me, Judge Carter, is there any condition under which you would approve a media request in your courtroom? Under any conditions, because this is a case that should be filmed. This is the case of first impression. I think it should be filmed. And he went on and on how he loves media and he wished it's a good thing in state court, but not in his federal court. And I said, well, aren't you the presiding judge? Don't you, sir, have the authority to set aside the rule? And to my amazement, he lied to me and he said no. So anyway, we left court after I had about a 15-minute discussion with Judge Carter, most of which I did the listening and he did the talking. But I did get in 3 specific questions. Don't you have the authority to set aside the rule? Isn't there freedom of press? Are there any conditions under which? And he basically said no. In federal court, no. This is specifically a case of first impression. And the amazing thing is about a week after it, I called Billy Renee Powers and said, did you get the court report? And she said, yes, but it stops right where I started to speak. So we're left thinking, did the judge play a fast one to let everybody think it's getting on the court record, but they struck everything after her attorney shut her mouth and the judge shut her mouth and just let Billy go on and on and on and on, reading her statement, but not getting on the official court record, so it can't be appealed to the federal appellate court and then to SCOTUS, Supreme Court of the United States? Is that what's going on? We don't know. But afterwards, we went outside, And aside from a guy named Borsatti who was putting up protest signs against the crooked judges in Chatsworth and Ventura County, we had Billy restate and reread the statement into the camera so you can now hear, and this is our good quality camera, we used a microphone. Listen carefully because this is a powerful statement that proves all these banks are involved in the perfect white-collar crime. I call it bank gangsterism. I hope Trump does something to put all these judges and these bankers in prison.
My case, Fernando Aldwin allowed Bank of America, who was in default, he set aside the default and he dismissed my case with prejudice. At the same time, I was in the Superior Court with the same law firm. They said U.S. Bank owned my house. When I went to Bank of America to sue Bank of America CEO, Bank of America CEO said they knew nothing about my house. They had no record of my house. They just, for 5 years, they've been fighting me saying they owned it. And then they wanted me to help them when I told them I can't help you because I never had an account or a contract, nor did I have anything to do with you guys. And I'm suing them.
And so you put in a jointer to this case.
To this case.
Billy Ray Powers.
To this case, because this case is the case.
Thank you.
All work together, that own each other's companies, and all are affiliated by UTA. Damn aspects.
We just finished in Judge Carter's court up on the 9th floor. This is William Wagener for On Second Thought. Renee Powers did get to make her statement. Her attorney showed up a little late. Judge started all over again to make sure the attorney was up to speed. And he tried to get them all to come to an agreement. That didn't happen. Renee suggested he grant her motion. They suggested they grant the 4 bank attorneys' motions. Bank of America is represented, Quality Loan was represented by the female attorney, right?
Mm-hmm. And then Stephen Daly is representing Bank of New York Mellon as the trustee. He didn't read out the trust because it's a fraudulent trust, so if he reads out the name, he's already committing a felony. And he's representing what he says is MERS. So he's representing MERS, Select Portfolio Servicing, and the Bank of New York Mellon as trustee, although the Bank of New York Mellon tells me they don't own the property or the loan and they have nothing to do with this. So, and we have that entered in evidence that Bank of New York Mellon, Gavin Sang, has made that very clear. So today, the goal today was to give facts and regulations as to why these banks are operating in fraud. They're operating in fraud because they're foreign banks. And foreign banks have no jurisdiction on the several states. They're only to operate in the insular territories and the 10-mile square of Washington, D.C. So what we know right now is these are all foreign banks who've been allowed to come on our land, usurp our rights and usurp our properties in complete fraud. And the Ponzi scheme Judge Carter talked about at the end, that story he told, I thought was very profound, because we've mentioned in our declarations and in everything that we're doing that this is a Ponzi scheme. It's the biggest Ponzi scheme in American history. So I feel very confident that Judge Carter did mention a Ponzi scheme because I know he knows that that's what this is. The legal argument I gave today after my attorney did show up and did make her presence known. What is also very exciting is that Judge Carter allowed me to speak as the woman. I didn't get shut up this time as I had in court before, where he told me to be quiet, only my attorney could speak. I think he can see that this attorney is not representing my best interests at this point, so he allowed me to speak. And I do believe that that's what happened here today. He recognized that this judicial system is not giving us homeowners a fair shake, and that's why he knows that I worked very hard, and our legal team, Carl Collicott, Maniva Curry, we worked very hard to get this pleading into this court so that it would be so easy a child could understand it. Carl's 94-year-old Aunt Dodie, when asked what she thought about the pleading, said, oh, it's easy. There is no loan, and they need a cash deposit of 100%. There's no cash deposit. She got it. So for him to say he doesn't understand it, I don't believe that. I do believe he knows completely what we're saying. He told me that I could speak, so this is what I said. Federal Rules of Civil Procedure, Rule 18 states, A, in general, a party asserting a claim, counterclaim, cross-claim, or third-party claim may join as an independent or alternative claims as many claims that it has against an opposing party. Right there, bam, that's it. That's our reason. Nobody can misquote that. Nobody can misunderstand that. We have a legal right to join as many claims against the opposing parties. So, this is a motion hearing on a motion to join claims, and the purpose of our being there today was to establish grounds for bringing forward these joinder claims. 12 U.S.C. Section 503 establishes my authority to bring these claims before the court. This motion is designed to conserve judicial resources and time available in order to make a complete argument for defining what I see as crimes committed by the banks. As regarding the factual background for this motion for joinder, what I have uncovered with the help of my research assistants, these beautiful people who've all showed up, everybody's pitched in, is that the banks that extend credit in these mortgage transactions are restricted by Section 23A of the Federal Reserve Act, Public Law 89-485, codified at 12 U.S.C. Section 371 to insular possessions of the United States. Such restriction is a territorial one to the 10 miles square federal government at Article 4, Section 3, Clause 2, which is not the Union of States federal government, at Article 4, Section 3, Clause 1. I have been able to isolate the statutes and regulations that congressional authority places upon these banks. The Constitution at Article 4, Section 3, Clause 2 says, "The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be construed as to prejudice any claims of the United States or of any particular state." The Congress, therefore, has authority to regulate these banks. However, enforcement of the compliance to these regulations is not occurring. What I have found is that the statutes and regulations are all restricted to foreign banks. The definition of a domestic bank is a member bank, affiliate of only a foreign bank. Reference 12 CFR Section 215, subsection 104, and a domestic branch of a foreign bank is still under the territorial restrictions of the foreign bank it operates from. 12 U.S.C. 248, subsection 1375. What I intend to prove is that these foreign banks are trespassing on the Union of States' real property without subject matter authority. Additionally, these banks can only operate in covered transactions. Please reference 12 U.S.C. Section 343, which requires that the bank make a 100% cash collateral deposit into an account prior to receiving the credit from the exchange of the promissory note at an international banking facility. We have no proof and evidence that these banks are in compliance with this mandate. I believe that Form FR 2900 establishes that such banks are required to account for such mandatory deposits before a financial transaction can occur. As the motion for joinder says on page 21, it appears that the United States disavows a liability for false representation of the acts of a corporation, such as these defendant corporations have falsely represented in extending credit beyond territorial limitations. Reference 12 U.S.C. Section 631. I believe there is more than sufficient evidence for felony-level violations expressed in 18 U.S.C. Section 1005, 1006, 1341, 1957. And for a memorandum in support, I now quote the following. The Supreme Court ruled in 1957 that it would be manifestly contrary to the objectives of those who created the Constitution to permit the United States to exercise power under an international agreement without observing constitutional prohibitions. Reed versus Covert, 1957, 354 U.S. 1. And what is going to happen if this court allows these banks to continue is that they are exercising a power under an international agreement, which is completely contrary to the Constitution. This is not permitted. Constitutional rights, particularly the 5th, due process, and the 7th, trial by jury, are guaranteed, not maybe, if it happens, guaranteed by the Constitution against invasion, i.e. foreign law. There are limitations of such powers which arise out of the essential nature of all free governments. Are we free or are we slaves? Implied reservations of individual rights without which the social compact could not exist, and which are respected by all governments entitled to the name. So is the United States of America entitled to the name United States of America in these 50 union states or not? I say we are. To lay with one hand the power of the government on the property of the citizen, and with the other to bestow it upon favored individuals to aid private enterprises and build up private fortunes, which we know is exactly what's happening in this Ponzi scheme across our country, is nonetheless a robbery because it is done under the forms of law. Anything done under the color of law, fraud upon the court. A government which recognized no such rights, which held the lives, the liberty, and property of its citizens subject at all times to the absolute disposition and unlimited control of even the most democratic depository of power, is after all but despotism. It is true, it is despotism of the many, of the majority, if you choose to call it so, but nonetheless despotism. Loan Association versus Topeka, 87 U.S. 20 Wall, 655, 1874. Despotism is the exercise of absolute cruel and oppressive power. And that's why I moved the court for joinder.
She certainly did, and when she finished that, there was an applause. Where's the applause now?
Yay!
Judge Carter did not take well to the applause from the 60-so people who had their joinders rejected.
Actually, there was 100 and at least 60. Not 60, there was over 160 to 180. He misquoted.
But there was 60 in court, and we literally filled that courtroom. It was clear to me, Judge Carter then went into a discussion of liquidity and the crisis, and basically looking at Renee and saying, well, a lot of people lost their homes in 07, and there was a liquidity crisis, and the government bailed out banks, even bailing out banks that didn't want bailouts, didn't need the bail, that were actually secure in their financial status.
Which, if you look at what I just read, that is exactly what is meant not to happen. It would be manifestly contrary to the objectives of those who created the Constitution to permit the United States to exercise power under an international agreement.
I get that.
And that's what that was, bailing out the banks.
Right.
That was an international agreement with foreign entities to give them the bailout, when in fact, if they failed, there would be no failure for us, just like Iceland. Iceland
arrested their bankers.
Arrested the bankers. They crossed out every mortgage in the country.
All the mortgages were canceled, and Carter is sitting on the chance
and 2 months
to
later,
do that here.
$30,000 was given to every citizen of Iceland. Every one of them. So what we have here is despotism in the event that Judge Carter does not rule properly, because as we know, the Constitution and the regulations I read today, the legal argument is right here, and under the FDIC versus Fitzpatrick, it gives me even further right to bring this cause of action privately. Come on over here, Maneva. Okay. Maneva is...
This is Maneva.
She's the paralegal. She wrote she's a legal assistant who did all the legal work.
I just want to say that Judge Carter, he's a fair man. And what I heard him say is he's going to go in his chambers and make a decision as to whether he's going to rule for a Fourth Amendment amended complaint so that we can coordinate and consolidate the joinder with the other claims, or rule. So that's what we're waiting for. We're waiting to see if he's going to just go on and rule for the Fourth Amendment complaint, and that's in our favor.
It is, and he did say that. He made it very, and he did shake his head and say which he's inclined to do. That's in our favor.
So that tells me that he does understand. He summarized very well about congressional intent, and had the bank stuck to what the Title 12 and regulations guidelines were, these people of our United States of America would not be harmed right now. So he did summarize that very nicely.
He seemed to be very knowledgeable about the fact that we have brought what no one has brought before him. And so with that said, I don't know about the rest of you, but when I've got something I've never had before me before, I've learned to stop, think, and before reacting,
and that's what he did.
Actually take time.
And that's what he did. Thank you.
Manora, come back. I'm not done with you yet. Stay close.
Switch side. Switch
side. The judge is sitting on a case of what I would call first impression. I say that after going to law school for 3 years and gone to 1,000 cases in law in 40-some states. He's sitting on a case of what they call first impression. It's going to be historic. If he makes the right decision, all these bankers are going to be in trouble. But one thing he made clear, all this stuff about frivolous lawsuit, he told Renee and her attorney when she finally came in, forget about that. There isn't going to be any retaliation for frivolous. This is not frivolous.
Yes.
He made that clear. But he also said, and this is what disappointed me, he also said, and we're not going to be contacting the Justice Department to have any of you attorneys prosecuted for what you've done. And Faith Brashear, who's here in the audience, she spoke up. She couldn't keep quiet. But it looks like he was giving a little bit to both sides. But Judge Carter, if you ever get on YouTube and look at this, I'm telling you something. If you make the right decision, which would be to find for Renee Powers and everybody who later gets an attorney and properly joins to this, he did say if you got an attorney or you owned a piece of her property, then you could join. So you need to find an attorney. I would suggest some of you call Susan Yu. She won the Michael Jackson case along with Thomas Mesereau, and she loves this kind of litigation. She doesn't leave any stone unturned.
Introduce Carl. Carl, come up here. Carl, come forward.
There was a room. Cindy Brown was there today.
Let's introduce today Carl Collicott. Carl, Maneva, and myself are the ones that put this pleading together. If it not for Carl's research of 25 years, this pleading would not have even made it into the court.
Yes. Did you enjoy this, Carl?
Immensely. I know it's a little setback in some ways, but the truth will prevail. There's simply no way to get around the regulations or the statutes enacted by Congress and executed by the executive branch. The judicial sole role in this is to enforce congressional intent in the implementing regulations.
Judge Carter seemed to be very stiff. I noticed there were 9 other cases went before your case. And he was always talking about saving litigation fees and being fair to both sides. So if he's going to be judicially following the procedure, he should probably then follow the congressional mandates, don't you think, Carl?
Absolutely. I can understand the reluctance, but it is a case of first impression, as you said. The truth will prevail.
I think the truth will prevail. Judge Carter, you have a chance to be the judge that's remembered for 100 years, to be the judge like the judge in Iceland in the parliament that said, we're done with the banks. They're not going to rob us anymore. And what Renee stated is true, but you never heard it on ABC, Fox News, or CNN.
John in here.
John, come on.
John came from Michigan to help our team. John,
long distance. We're in California. If you didn't notice, we're in hot, sunny Santa Ana, California. Here, John.
Thank you for the opportunity to speak today. It just so happens that the attorney that was on the original Credit River decision in Credit River, Minnesota, is Judge Bill Drexler, and he's been a personal friend of mine for over 20 years. So I'm happy to say that the inspiration that people like Judge Bill Drexler gave to all of us through that common law decision is being now brought forward into Billy Powers' case. And I'd like to quote Abraham Lincoln to inspire everybody that has been a victim of foreclosure to file a claim through the help and assistance of an attorney, and let's work at getting everybody relief. Abraham Lincoln said this: "The people are the masters of the Congress and the courts, not to overthrow the Constitution, but to remove those who would attempt to pervert it."
Well said.
Move forward, and thank you for your time. Thank you for showing up. Thank you for supporting Billy Powers.
Well, there you have it. There's one more little item that did not get mentioned in court. Apparently last Friday, and that's why I want Minerva close to me. Last Friday, excuse me, Minerva. Last Friday, there was a meeting in the office of Attorney Angela Swan. Can you describe who came in and what was said, Minerva?
Oh boy, you're gonna put me on the spot like that, huh?
Yep, I am.
Okay.
That's why they watch.
An employee came in, and
employee of who?
Of Angela Swan.
Okay.
Without my knowledge, I knew not who he was, so it's violating client-attorney privilege.
He came in unaware of a lot of facts regarding the case, and insulted us, and the meeting was over. He insulted all of us.
Did he?
He said that if she went forward as an attorney against the banks, she would lose her bar card, and that we could not have her. And he also said to me, now mind you, I met Angela through Minerva. I had never met her, didn't know who she was, didn't know if she was the color of green or a grape or what. This man says to all of us in the room, what brings you up here to hire a black woman to handle this case? Why do you need a black woman to handle this case? At that,
did he say that, Minerva?
Yes, he did.
We were all in shock.
Yes, he did.
It's
very hurtful. It's very hurtful.
This was an employee of...
This is her private investigator who was sitting in the courtroom, and Judge Carter actually looked at him at one point and made a comment, and it was him it was directed at.
Oh.
Yes.
And this didn't get mentioned in court.
Well,
no, it didn't.
I don't. Sometimes we have to remember.
Do you think Judge Carter knows this threat was made last Friday?
Well,
he knows something has taken place. He knew something. He knew that there was dissension.
That's why he thanked Swan for showing up.
Yes, he did.
He didn't scold her for being late.
And he obviously favored me today in knowing that something that happened was not in my favor with that attorney.
Right.
Because that's why he allowed me to speak in my belief today. And when you have a woman like me who has never met this woman, I said, when Minerva said, I've got the woman to handle your case, and I was talking to other attorneys who called to handle this case, and I said, she says, what, you're not going to have Angela do it for you? And I said, you know what? Because you're telling me she's the one, we're doing it. I had no idea until I went to the office.
Neither of us.
My whole thing, once I did find out, was how, I'm getting goosebumps now. Think about it. A black woman attorney leading our country out of peonage and debt slavery? You don't get more Rosa Parks than that. Look at these goosebumps. This was about color. That man,
yep, she's got goosebumps.
That was reverse racism. And if anybody that knows me, I have no racist bone in my body. None. If you look around at the friends who support me and I support, there is no color. This is a case for America. This is the peaceful revolution of all of this as Americans standing here. Look around. Look around this. Look around.
It's a melting pot.
This is not what that attorney should have done to me. And when I stood up and I said to her, I don't want him in this room. He needs to leave. She didn't let it. She let him keep attacking all of us.
How long did that go on, Renee?
It seemed like a year, but I have no idea because I was in utter shock. I started shaking, as Cindy Brown can tell you, as my ADA who was there today.
Do you think that's why your attorney Swan was late today?
Oh, she was late today because she already told me she quit this morning. And I told her, you are going to stand there and you are going to be professional and you are going to read what we prepared for 3 days in your office. You are not going to stand here and tell me you cannot go against the banks.
What do you think got to her employ the
All I know is Stephen Daly. I'm just going to make a subjective observation here. When we were in the court, and remember he left and this attorney came back in and Judge Carter said, what, are you lost? That was Stephen Daly. That was SPS, Bank of New York Mellon Murr's attorney. Now, you want to talk collusion, how do you have all three, right? But then he left, and shortly after that, she appears. I believe he was meeting with her.
Wow. Just for your info, alone on the elevator, I came down. There was one woman who I maybe won't mention, and there was a bailiff, and Stephen Daly and myself came down the elevator, and I asked him for a comment, if he would say something on film. He said, no comment. I said, well, just for a minute. No comment. He wasn't going to say anything. And that was my question. Did you hire somebody or do something to make that shameful?
She was scared. You could tell in her office she was, I believe, she looked scared.
But she did show up today.
Well, she had to, because you know what happens in Judge Carter. If you listen to him today, you don't not show up in his courtroom.
Do you think that's the call he took a break to make?
I think so.
I think so too. So this is what was going on in the background that was never on the record. I think you people need to call the Bar Association and anybody listening on YouTube and say, we want Stephen Daly's bar card revoked until he proves in a court he did not cause that meeting Friday and what we saw take place.
We also had a attempted break-in Friday morning. So this all occurred on one day. So we had an attempted break-in, and then we had her do a complete 7 o'clock at night after we spent 3 days creating this opening statement. So we had all the facts. 7 o'clock at night on Friday, knowing we had to be in court at 8:30 Monday morning, she says, I think I'm going to have to sub out. I cannot go against the banks. I'll lose my bar card.
Thomas Resero would not sub out. He specializes in criminal cases. His former partner, Susan Yu, is very good on the civil side. And I would just recommend again, if you care about this case, call Susan Yu, call Thomas Resero and their separate offices, and ask them to step into this case, because I got a feeling, one way or another, this case isn't over. The judge may rule for her or against it, but it's going to go up on appeal. This is a SCOTUS case. This is a landmark case. I'm not even going to go into how my computer was tampered with in the last week, so I couldn't. Come here,
Faith. Let's get Faith on camera.
Come on, Faith. This is Faith for sure. She had a separate case. She was almost attacked in her home by people. Thank you, Minerva, for testifying to that.
Thank you, Minerva. Yeah, so I've created and posted up with the assistance of a lot of people that are in the industry who have been in the IRS in different levels, who have been with the Department of Justice, even an FBI guy who was thrown out to the street because the banks took his house. So this is not just happening to us, it's happening internal to government employees, and there is a line that is definitely crossed. But the DisLeague website has been threatened. It's not so much threatened, it's been, can you please take this down? Can you please take your site down? I said, okay, fine. I don't know who you are, but you get us a court order that states that you want it down, because right now everything's disclosed under the First Amendment rights, as we were lovingly discussing with the judge this afternoon. You were.
Yeah. Thank you, Faith. Going back to when it was all, let me get this in. When it was all over, I said, excuse me, Judge Carter, because I'd put in a media request. I have a copy here somewhere in my pocket. They got it, and Deborah, his assistant, told me it was denied. But I didn't get the denial signed with Judge Carter. So I asked Judge Carter, is there any condition under which you would approve a television media request? And he went into a 15-minute monologue. I mostly listened and said thank you. But he said, never, never, we won't allow television in federal court. Never. That's what he, and I said, well, are you in, but he went on to say, but I'm very much in favor, and state court, knock yourself out. I mean, it actually helps bring justice forward. Judge Carter said that. TV cameras in court can force people to speak justice and spell the truth out for everybody. So I said to him finally, are you inviting me to file a motion to break the rule and run it up to SCOTUS? And he said something to the effect of what? Knock yourself out?
No. If it moves your soul.
Yeah, if it moves your soul. I mean, I take that as that. Knock yourself out. If it moves your soul, put it in there. I was shocked that he said, even as presiding judge here in this courthouse, the Ronald Reagan Federal Courthouse, he did not have the power to break that rule. That's what he said. Whether it's true or not, somebody else will decide. Okay, now,
So what I
Renee, did you have one last comment?
Yeah, what did you want me to say?
Faith actually put together an amicus curiae and
did.
sent to the Federal
Court of Claims.
The Federal Court of Claims
In Washington.
And her claim has been accepted to go up. She's now got to serve the Department of Justice.
Right.
So one way or another.
It's going to get
Our
there. The
team-
joiner's going to get there because
Wow.
the joiner was mentioned in the complaint itself, incorporated the arguments therein.
This is what we call Plan A, Plan B, Plan C, and the plan. Ongoing. So there is no failure. There is no quitting. They've SWAT teamed us. They've beat us up.
Yep.
They've stolen everything down to our underwear. And
Yep.
I'm going to tell you what, you can always buy new underwear. You can't replace your family. And you
Or
can
your
get,
memories,
or your memories, and you can get rid of those who commit the crimes. You just have to be very specific. And you saw, this is the fairest judge I've ever seen.
Yes, I love it.
You're not going to get this kind of justice anywhere. Regardless of how he rules, we will appeal if we have to. But what we saw in there today, him allowing me to speak, knowing I had insufficient counsel sitting next to me, was huge. So we do have to say that we know justice, what is that sentence? Justice, what is it? No, Jack? Justice delayed is
Justice denied.
Thank you, Daniel. So he doesn't delay justice, and he will get it out, and he's going to speak very well about this. And I tell you, from what I've heard from people who know him, he doesn't sleep. His wife probably has seen him less than anybody in the country has ever in their marriage, because he works hard, and people who know him say he's fair. So if something comes down against us that doesn't seem right, it's probably because we missed something. And today, I don't think we missed a thing.
Those of you who watch my YouTube clips, and this will be on YouTube after it's on my live television show, about a month ago, every YouTube clip I had that mentioned bank foreclosure, the California I-10, it disappeared for a week. And I was dumbfounded. And a week later, just as mysteriously, it all reappeared.
You're talking about the California 18 again.
The California
And the
18?
California 18's premise was recording fraud that was allowing the theft of our homes. And we took all of this through CJ Holmes to Kamala Harris, and she said she was going to completely investigate. A year later, we found out not only did she not investigate, but also in March of 2014, the Inspector General of the United States put out a report that said the FBI and all of the Attorney Generals did nothing. None of them investigated one thing. So when Judge Carter said that even the Department of Justice didn't look at this, oh no, they looked at it.
Yes, they did.
They
They have been sent every file, every inch, every detail, even every IP roaming address that has ever been used to record these falsities.
So we've had them looked at. But again, the President of the United States can't even get Hillary indicted. And he's going to say...
And the proof is obvious, and everybody knows it, and he can't get her indicted. That tells you what we're up against. Did you want to say something?
Yeah, I do.
Tell us who you are.
My name is Terry DeMuth from San Diego. I didn't make a house payment for the last 9 years. And they finally came after me after I filed my truth in lending, my truth in lending violation. I followed Neil Garfield from Living Lies. We filed it, gave him 2 chances on a number of days, 15 days to respond. And then I filed my action, all filed with the county recorder, removing anything that they said was possibly a lien, because there's not one there. And there's nothing.
There's no mortgage.
They foreclosed on me a year later. Now, if you understand the law, this guy that talked from the title company today, if you take a look at when there's an auction on your home, there's a stamp on there because it has to be guaranteed.
Yes, the accommodation stamp, we've argued that.
It's already got to be there, and here's the problem though. I went back to the trustee, who was another law firm, who became the trustee somehow, out of God, which is all RICO violations. Everybody's got a problem with this, and I agree with it. Yeah. They turned around and they delayed my sale by 1 day, and they made sure that the next day that there was nobody present except for me.
Of course, that's what they do.
Okay, but let me make a point here. This story that you're telling can be repeated a million times over. But let me you're going to finish this, but let me finish. But what's important here is all of these stories, these are the damages. The actual conduit is the fact that they're foreign banks with no right to do business by congressional regulations in the 50 several states. So all of these stories, we don't need to keep repeating them anymore. Because you know what? Everything is void right from the get-go. There are no contracts. You're the bank where the energy comes from to create the credit, and they have no right to take that credit. And as a homeowner, the definition of homeowner in congressional regulations is member bank. So it's a trickery. They cannot lend to the people or the public at large. They cannot lend credit to the people or public at large.
Say that again, Renee. Renee, step forward. Say that again slowly.
Okay,
You
the
speak
banks.
fast.
I know I do. Even Judge Carter.
Even
tells me to
Judge
slow
Carter
down.
said,
and that
"Slow
was
down."
slow. That was slow. So
Say it again.
The banks have no right to lend in the several states. They can only lend to foreign banks. Member banks are foreign banks. The definition of homeowner in congressional regulations is member bank. The foreign part of that homeowner sits at the Federal Reserve in accounts that they access the credit from that are in each of our names. So, with that said, they have no right to lend credit to the people or public at large. And I don't care how hard Mr. Britt gets up there and says, Bank of America, they're open. Okay, well, guess what? They're open in fraud because branches cannot loan, branches cannot conduct banking other than in the domicile of the foreign bank. Deutsche Bank AG, its domicile is Germany. Credit Suisse, where else? Switzerland. So we have a situation here that we have a judge who has everything in front of him that even a 94-year-old aunt can understand. None of us have loans. There's no credit cards. There's no anything. Again, I go back to Iceland. Everything's zeroed out. We call that the Jubilee.
That's right.
And 2 months later, $30,000 in credit, as we know, gets deposited for every citizen of Iceland. And the bankers were kicked out. They were jailed and kicked out of the country.
18 of those bankers in Iceland are still serving time. 5 or 6 managed to get to their private jets and flee from Iceland back to Amsterdam and London. But there's more than a dozen still serving time out at the end of a long, long road where it's very, very cold all the time, and they don't even have a fence around their prison because they'd freeze to death if they tried to walk back to the nearest Icelandic city.
So with that said, I'm going to go have lunch and see
at
my
the Yard
kids
House, right?
at the Yard House. We're going to the Yard House in Costa Mesa if anybody wants to join us. We're going to sit on the patio and just have something to eat. And I got to tell you, I am very moved that we had the people here because you guys got to know, I didn't have to bring this case, and this is my case, but all of those interested party forms, that wasn't my idea. That came out of Florida. And I just thought, I made a call to our Jane Doe, who was a federal prosecutor, 35 years, prosecuted the banks, and she said, that's brilliant, because they hate class actions, they hate joinders, and she said, you know what, because you're the one leading the pack, they don't have to worry if all comes down and it does go to the DOJ, because you're going to make sure everybody gets an award. And I said, exactly. So with that said, even though he said this isn't your case because you don't own my house, what he failed to realize was these fraud charges, these congressional regulations do affect every one of you. So when he says you're not an interested party, that is the only thing today I strongly disagree with, because as far as congressional regulations go, we are all interested parties in the outcome of this case.
Very interesting.
He did say, though, if you get an attorney, then you could join this case. Terry, did you want to finish saying something? Face the camera. The camera's over here.
You don't want to look at me anyway. Well,
Go
sorry.
ahead. Go ahead. Go ahead. Say,
Well, here's what happened. I'm going to just finish what happened to me, though. So they finally take me to the unlawful detainer court, right? And they have the lawyer that did the foreclosure filed an affidavit, you know, firsthand knowledge. And I filed my demurrer, and of course it was rejected by the bank. I mean, the judge rejected them. So they had 15 days to come back and have the banker sign the document. I want you to understand that. The banker has to affirm that there was ever a loan, because that was part of my demurrer. So you know what happened? The servicer out of Florida, which is a foreign corporation, and I know that because I did my research on that, came back with a power of attorney, which I know was not real because it was never filed, and said he had power of attorney and he had first-hand knowledge. That got rejected too by the judge kicked it out. I broke my hip, went in the hospital, went in a nursing home. They tried to go and do an eviction on me. They went to the clerk of the court. The first two said no. The third one said, yeah, failure to appear. Well, I'd already called the court and said, I'm in the hospital. I can't be anywhere. I went down to my eviction hearing, and the same judge, who people don't like, and I know he knows what's going on now, said, start over again, lawyer. You know what they've done to me now? They went to a silent auction, folks. There's a silent auction out there you don't even know about. It's online. 4 times to try to get a minimum bid on my home because it was like they're going to have to come up with $1 million. That's what they said they paid. But when I filed that truth in lending action, a violation on that, and I filed that there's no lien on my property, that bank sold my property, they say, back to themselves, which doesn't make any sense. Why would you purchase something you say you already loaned? Why would you write a check out for $1 million and say, I just bought that note because it's in my paperwork? And if everybody understands, you start looking at the documents they filed with you in court. BNY, Bank of New York Mellon, Bank of New York, there's 3 different entities. Wells Fargo's got 46 different entities. Which one are we going to go after? Because you got to understand something. They all have different EIN numbers. They all have different responsibilities in the world, right? The other thing that was even better was I got a 1099 no deficiency. Okay, I owed $1.6 million on my house. My house was worth that, but they got it for $1 million, right? My deficiency said 0. Well, wait a minute. It's going to get better now. Who did I get the 1099 from? The servicer. They said they're the lender on the document. So you want to tell me now there's no fraud in this action here? They don't even know where they're all at because usually the servicer is the one that takes the house, not the bank. And they flip it over. That's what the law firms and everything else they've been doing.
Yeah, I can affirm what we saw is 4 well-heeled attorneys against Renee Powers, at first sitting all by herself. And these 4 well-heeled attorneys all seem to say, not me. All I did was do the foreclosure. Not me. We didn't originate this loan. Not me. We just did this or that. Only Bank of America implied maybe they had something to do with it because they took over Countrywide. Well, that's
how they do that. You take a look at all the banks out there. You got Michael Dell from Dell Computers. You got Henry Paulson, IndyMac Bank. All those banks, Bank of the West, they flipped one out. They got more money from the federal government again and bought the notes from another bank. There's always an in-between bank that goes under right away.
I want to tell you, people that are listening out there, there's a slang, you can't beat the bank or you can't beat City Hall, same thing. Well, there's someone here that did beat the bank, and I was the only person in the gallery, not just the only media, the only person in the gallery. It was a case of Ragland versus Wells Fargo, and that, U.S. Bank. And Pam Ragland's here. And the most astonishing thing, she'll validate this. Come here, Pamela. This is Pam Ragland. She won her case, and you collected money, finally.
Yes,
right?
I did.
But your own attorney was a little sticky with letting go of the money, right?
Yeah, we're still fighting that.
But she got a good chunk of the money. But the most astonishing thing in her case is the attorneys for the bank. I think there was 3, 4, or 5 of them. Only 3 of them could sit at the table. The senior ones were sitting in the back looking at the younger ones. And I guess the attorney was named Michael. He stood up and went to the jury, and he said, well, just because the bankruptcy judge said she's got X amount of days to come up with all this money, and we foreclosed right away the next week, you wouldn't hold that against the bank, would you? And I'm like, what? Did he just say that to a jury of people, of living human beings? Yeah, they would hold it against you. That case ended at noon. They settled with her current attorney, didn't they? Called him during the lunch hour?
Yeah, they ran from the courtroom.
I caught them in the elevator, and I said to the whole bunch of these attorneys, says, excuse me, but did you resell her loan 6, 7, or 8 times? Mm-hmm. And the senior attorney, the woman, said, no comment. And she looked at Michael and said, no comment. Making it clear nobody was going to comment or say anything to that question. To me, that was an admission of guilt. That was an admission. They took her paperwork and resold it again as each person was buying it for the first time.
You're right, but here's
they
the
weren't
thing.
going to talk about it.
Entitled to her was her note.
Yeah,
that's why they don't want to admit it. My son, we just got through a year ago. We got a settlement on his house for 2 failure to appears. 2 times they didn't show up. Then the judge sent the subpoena out to I won't tell who it is, but they sent it out to him. They didn't appear again. So we're sitting in court, and the judge said, what do you want? $800,000, $50,000 to the lawyer. That's what he agreed on, because we know the lawyer. And she said, okay, but you have to understand this. They got 6 months to appeal it. I said, but you want to give me 30 days for failure to appear. I want you to understand this, what they said, because it's an entity. A business entity can get 6 months. Well, if we all study what we're supposed to be, then why don't I have 6 months? Because I'm supposed to be a corporation too, right?
Anyway, the lesson here is...
I can talk about Wells Fargo
Sure,
too.
go ahead.
Okay, so now I have the mic. I can talk about Wells Fargo too.
Not too close.
I can still talk about Wells Fargo because we are not done yet. So as I was wrapping up my case with U.S. Bank, I leased a house for 5 years, and Wells Fargo promptly illegally foreclosed on my house. And under California and federal law, both I had a right to stay in my house and live out my lease. But Wells Fargo promptly started trying to evict me within a month of when they filed the trustee's deed upon sale. Nobody knew about the sale. The owner was not noticed.
Right before Christmas, wasn't it?
The first one was right before Christmas, and the second one was in the second case right before Christmas. So I opposed that. They dismissed their motion, tried to sell the house instead of following the case law that says they have to be the landlord. I discovered that a bunch of things like the state of the property and things like that. I actually offered to buy the house. They ignored me and they tried to evict me again. So I opposed it, and then I finally hired attorneys because I was leaving the country. And this eviction went on for 4 years. And what I did that everybody can do here is I proved that Wells Fargo did not own that house. I requested documentation to prove that that house was in the loan, that that loan was in the trust. I requested information to prove that that trust was still a viable entity, because here's something basic. If you have a trust and the trust is closed and it's not reporting income, it's like a person who's dead. You cannot represent a dead person. You cannot represent a closed business. You cannot represent a trust that is no longer viable. You have no client. So who is the client? Who is getting the money when they foreclose on this house and they sell it again? Everybody can do this. It's called standing. They don't have the right to evict you from a house if they don't own the house. That's California law. So I made them prove that they had standing. So we finally deposed their person most knowledgeable, which was Aquin, after 4 years. And originally Wells Fargo had said it's not us, it's Aquin. Aquin testified 17 times in that deposition that they were operating on behalf of Wells Fargo. Every time I started raising Cain on Facebook and things like that, and they gave me an executive with Wells Fargo, they happened to be able to easily find the loan right away. So of course Wells Fargo was involved. And he denied knowing who Linda Green was, because this house's first assignment was 3 years after the loan was originated by Linda Green. We all know Linda Green never existed. Linda Green was the fake name made up at DocX to forge a bunch of loan documents because they stole loans and they don't have them. So in my afternoon deposition, the attorney for Wells Fargo asked me, do you think the banks are committing fraud? And I looked right at him and I said, I don't think they are. I know they are. And he said, like what? And I said, fake deeds, fake assignments, fake notaries, and Linda Green. And his face turned white. And then the other thing we have found out is Wells Fargo and Aquin do not have a process to follow the law for renters in California, or anywhere for that matter. They think the foreclosure trustee does it. This means that 60% of all the foreclosures, people are being illegally evicted from their homes because they have a right to be there.
Thank you.
Yes. And if I could just wrap this up. Shortly after that deposition, Wells Fargo dismissed the 4-year eviction against me.
Isn't that awesome? She won money. Now she's got to get it from her own attorney's hands. See, the money went to her attorney, and she's trying to get it. I think you made a good deal with him at, what, $100 an hour? And then he said, no, he wanted the percentage when he saw where this was going. They didn't want this thing to go to an afternoon session. I heard the opening statement when they said, you wouldn't hold that against us just because we broke a federal bankruptcy judge's order. You wouldn't hold that against the bank, would you? Yeah, they did. And they knew they were going. You could see it in the jury's faces. So they settled for a sum she can't disclose. But my guess, it's somewhere between 1.1 and 1.5 million. But she can't tell me because that's part of her. Okay. Well, that's it. That's a wrap. I'm William Wagener down here at Santa Ana Courthouse, where I think, if nothing else, a second American revolution to free ourselves from debt slavery has just begun, regardless how Judge David O. Carter, Semper Fi Marine, a former U.S. Marine, is going to rule tonight, tomorrow, or the next day, or maybe he won't rule at all. He'll just sit on it. I don't know, but he seemed to be trying to be fair. And a disbarred attorney told me last night, Judge Carter is the fairest judge you could probably luck out to get. So with that, I bid you adieu, William Wagener. Thanks for watching.
Thank you, William.
Well, people, as you can see, I'm the brilliance of the light of truth spoken here is so great. I had to put on my sunglasses to protect my eyes. And the scumbag cockroaches that generally filter in and fill up the lawyers' shoes in those courthouses, they couldn't even stand to be here. They're hiding somewhere in some dark corner. You just saw an on-the-scene interview, not just with Billy Renee, but Terry from San Diego, Pam Raglan, who I was the only person in that courtroom besides the attorneys, the jury, and the court reporter. And to this day, Pam Raglan has still not disclosed how much money she settled for. But she had those bank gangsters up against the wall, and I knew it when I heard the opening statement of that attorney, Michael, what's his name, look at the jury in the face, and with a straight face, he says, you wouldn't hold that against the bank just because we violated a bankruptcy judge's order to stay all actions for 30 days. You wouldn't hold that against the bank, would you? And I'm like, really? This is the best you can do in your opening argument? You admit you violated a federal bankruptcy judge's order, and you expect the jury to go along with you. Oh my God. I mean, laughing. So it was fun pinning those high-priced attorneys at the elevator, and that senior female attorney, she looked at the other attorney, no comment. We have no comment, no comment. Yeah, they're guilty, just like those bankers in Iceland. And these attorneys that showed up in Raglan's case, in Terry's case, in Billy Renee's Power case, there were 4 of them, each representing 4 major, from B of A to, I think it was called Loan Servicing Corporation. All of those attorneys should be handcuffed and put in jail until they can have a trial, and their bail should be no bail until you've had your trial. And then let's see how they dance when they got to stay in jail with no bail, how long it takes them to break down and say, oh gosh, okay, I'll cop a deal. I'll squeal against my seniors and my co-partners if you just let me out of jail for time served. These are the epitome, people, of a white-collar criminal. They're called members of the Bar Association. The California Bar Association, the Texas Bar Association, the New York Bar Association, the Maryland, the Virginia, the Delaware, the Ohio, Wisconsin, all these bar associations, all these attorneys that represent or claim to represent. And here, let me differentiate something. I have talked to some bank officers on specific cases where they said, I don't know what you're talking about. This attorney that says he represents us, we have no dealings with that attorney. He doesn't represent us. So what they're saying to me is you've got rogue attorneys claiming they represent a bank and they don't. Really? Really? And no attorney general wants to dig into this? I'm sorry you missed the California 18 show we had here, was it 3-4 years ago? Renee Powers, who you saw speaking most in this video and read that powerful statement, citing congressional law and a Supreme Court decision that upheld the congressional law that these member banks can't make you or me a loan in the 50 states. Now, if you're in a federal district, or if you're in Washington District of Criminals, District of Columbia, which really should be now called District of Criminals, because that's mostly what habitates there. These people, there they can make loans to the government, but they cannot make loans to you and me. And yet they get you to sign all these papers, and you're signing, initialing, and we all know 99% of us that get home loans don't read the darn thing. And we never see the bank officer actually sign it. We just sign it. What you're really doing is you and I are creating the money because they don't have a collateral account. Like say B of A got $50 million here and they lend you $1 million loan on a house, then they should only have $49 million. Well, they don't even have that. They don't have anything. You and I create the money. That's what Billy Renee Powers is trying to educate you on. And this makes a major, major difference. But until enough of you understand this and hold your judges accountable, hold attorneys accountable, hold the Attorney General accountable for not prosecuting this perfect white-collar crime. And I've watched it over and over and over and over, and the judges always bow down to the banks. Even when the evidence is blatant, in your face, irrefutable, they rule for the bank. I would like to go back on this tape and show you the beginning that we didn't show you at the beginning of the show, because I mainly wanted you to hear what Billy Renee Powers had to say. This is, like Carl agreed with me, this is a case of first impression. And ours was the only cameras there rolling. Amazing that the corporate media that goes to the same bank gangsters to get their corporate loans to refinance their new Atlanta headquarters, New York headquarters, Los Angeles headquarters, they didn't show up. I wonder if you can't trust the corporate media to tell you the whole story. But if I can get the whole story, I'll show it to you. Are we ready? There's this guy named Dan Bersati. He's got a case coming up next week. I just got confirmation that the court got my media request. He was putting up signs about all the crooked judges in Ventura County. He's got a hearing, I believe, in the Chatsworth State Court. I think it's a state court in Chatsworth, which is a suburb of Los Angeles. He's putting up all these signs and exposing the crooked judge. Now, he came all the way from Ventura to Orange County and didn't even hear the hearing. He was busy keeping his signs from being blown away by the wind and letting all the attorneys and people go by see the faces of the dishonorable, and let me say that again, dishonorable judges. Roll it. This was at the Ronald Reagan Federal Courthouse, 9th District, Santa Ana. Yeah, it's a nice view of me from the side. Hi. There's the view from the top of the parking structure of the Ronald Reagan Federal Courthouse. I'm going to zoom in on the very impressive symbol at the top. But I believe if Ronald Reagan knew the corruption that has slipped through that courtroom, many of those courtrooms, he would be disgusted to have his name on that building. Because Ronald Reagan was a man of the people.
Got some rubber that I can cut for this so that you can have a nice connection on your stand.
You know, Mr. Wagener, I don't think you're allowed to do this out here. Okay. What do you want to say?
Your case.
Okay, my case, Fernando Aldwin allowed Bank of America, who was in default, he set aside the default, and he dismissed my case with prejudice. At the same time, I was in the Superior Court with the same law firm. They said U.S. Bank owned my house. When I went to Bank of America to sue Bank of America CEO, Bank of America CEO said they knew nothing about my house. They had no record of my house. They just, for 5 years, they've been fighting me saying they owned it. And then they wanted me to help them when I told them I can't help you because I never had an account or a contract, nor did I have anything to do with you guys. And I'm suing them.
And so you put in a jointer to this case.
To this case.
Billy Ray Powers.
To this case, because this case is the case.
Thank you. Yeah, there's one of the so-called, and this is a case of first impression, and it's really worth hearing what she had to say. Can we fast forward ahead to where she starts reading her statement, Stephen?
All over again to make sure the attorney was up to speed.
So today, the goal today was to give facts and regulations as to why these banks are operating in fraud. They're operating in fraud because they're foreign banks. And foreign banks have no jurisdiction on the several states. They're only to operate in the insular territories and the 10-mile square of Washington, D.C. So what we know right now is these are all foreign banks who've been allowed to come on our land, usurp our rights and usurp our properties and complete fraud. And the Ponzi scheme Judge Carter talked about at the end, that story he told, I thought was very profound, because we've mentioned in our declarations and in everything that we're doing that this is a Ponzi scheme. It's the biggest Ponzi scheme in American history, so I feel very confident that Judge Carter did mention a Ponzi scheme, because I know he knows that that's what this is. The legal argument I gave today after my attorney did show up and did make her presence known. What is also very exciting is that Judge Carter allowed me to speak as the woman. I didn't get shut up this time as I had in court before, where he told me to be quiet, only my attorney could speak. I think he can see that this attorney is not representing my best interests at this point, so he allowed me to speak, and I do believe that that's what happened here today. He recognized that this judicial system is not giving us homeowners a fair shake, and that's why he knows that I worked very hard, and our legal team, Carl Collicott, Maniva Curry, we worked very hard to get this pleading into this court so that it would be so easy a child could understand it. Carl's 94-year-old Aunt Dodie, when asked what she thought about the pleading, said, "Oh, it's easy. There is no loan, and they need a cash deposit of 100%. There's no cash deposit." She got it. So for him to say he doesn't understand it, I don't believe that. I do believe he knows completely what we're saying. He told me that I could speak, so this is what I said. Federal Rules of Civil Procedure, Rule 18 states, A, in general, a party asserting a claim, counterclaim, cross-claim, or third-party claim may join as an independent or alternative claims as many claims that it has against an opposing party. Right there, bam, that's it. That's our reason. Nobody can misquote that. Nobody can misunderstand that. We have a legal right to join as many claims against the opposing parties. So, this is a motion hearing on a motion to join claims, and the purpose of our being there today was to establish grounds for bringing forward these joinder claims. 12 U.S.C. Section 503 establishes my authority to bring these claims before the court. This motion is designed to conserve judicial resources and time available in order to make a complete argument for defining what I see as crimes committed by the banks. As regarding the factual background for this motion for joinder, what I have uncovered with the help of my research assistants, these beautiful people who've all showed up, everybody's pitched in, is that the banks that extend credit in these mortgage transactions are restricted by Section 23A of the Federal Reserve Act, Public Law 89-485, codified at 12 U.S.C. Section 371 to insular possessions of the United States. Such restriction is a territorial one to the 10-mile square federal government at Article 4, Section 3, Clause 2, which is not the Union of States federal government, at Article 4, Section 3, Clause 1. I have been able to isolate the statutes and regulations that congressional authority places upon these banks. The Constitution at Article 4, Section 3, Clause 2 says, "The Congress shall have power to dispose of and make all needful rules and regulations respecting the territory or other property belonging to the United States, and nothing in this Constitution shall be construed as to prejudice any claims of the United States or of any particular state." The Congress, therefore, has authority to regulate these banks. However, enforcement of the compliance to these regulations is not occurring. What I have found is that the statutes and regulations are all restricted to foreign banks. The definition of a domestic bank is a member bank, affiliate of only a foreign bank. Reference 12 CFR Section 215, subsection 104, and a domestic branch of a foreign bank is still under the territorial restrictions of the foreign bank it operates from. 12 U.S.C. 248, subsection 1375. What I intend to prove is that these foreign banks are trespassing on the Union of States' real property without subject matter authority. Additionally, these banks can only operate in covered transactions. Please reference 12 U.S.C. Section 343, which requires that the bank make a 100% cash collateral deposit into an account prior to receiving the credit from the exchange of the promissory note at an international banking facility. We have no proof and evidence that these banks are in compliance with this mandate. I believe that Form FR 2900 establishes that such banks are required to account for such mandatory deposits before a financial transaction can occur. As the motion for joinder says on page 21, it appears that the United States disavows a liability for false representation of the acts of a corporation, such as these defendant corporations have falsely represented in extending credit beyond territorial limitations. Reference 12 U.S.C. Section 631. I believe there is more than sufficient evidence for felony-level violations expressed in 18 U.S.C. Section 1005, 1006, 1341, 1957. And for a memorandum in support, I now quote the following. The Supreme Court ruled in 1957 that it would be manifestly contrary to the objectives of those who created the Constitution to permit the United States to exercise power under an international agreement without observing constitutional prohibitions. Reed versus Covert, 1957, 354 U.S. 1. And what is going to happen if this court allows these banks to continue is that they are exercising a power under an international agreement, which is completely contrary to the Constitution. This is not permitted. Constitutional rights, particularly the 5th, due process, and the 7th, trial by jury, are guaranteed. Not maybe, no, if it happens, guaranteed by the Constitution against invasion, i.e. foreign law. There are limitations of such powers which arise out of the essential nature of all free governments. Are we free or are we slaves? Implied reservations of individual rights without which the social compact could not exist, and which are respected by all governments entitled to the name. So is the United States of America entitled to the name United States of America in these 50 union states or not? I say we are. To lay with one hand the power of the government on the property of the citizen, and with the other to bestow it upon favored individuals to aid private enterprises and build up private fortunes, which we know is exactly what's happening in this Ponzi scheme across our country, is nonetheless a robbery because it is done under the forms of law. Anything done under the color of law, fraud upon the court. A government which recognized no such rights, which held the lives, the liberty, and property of its citizens subject at all times to the absolute disposition and unlimited control of even the most democratic depository of power, is after all but despotism. It is true, it is despotism of the many, of the majority, if you choose to call it so, but nonetheless despotism. Loan Association versus Topeka, 87 U.S. 20 Wall, 655, 1874. Despotism is the exercise of absolute cruel and oppressive power. And that's why I moved the court for joinder.
She certainly did, and when she finished that, there was an applause. Where's the applause now?
Yay!
Judge Carter did not take well to the applause from the 60-so people who had their joinders rejected.
Actually, there was 100 and at least 60. Not 60, there was over 160 to 180. He misquoted.
But there was 60 in court, and we literally filled that courtroom. And I didn't raise my hand because I'm media, and I didn't file a joinder. But it was clear to me, Judge Carter then went into a discussion of liquidity and the crisis, and basically looking at Renee and saying, well, a lot of people lost their homes in '07, and there was a liquidity crisis, and the government bailed out banks, even bailing out banks that didn't want bailouts, didn't need the bail, that were actually secure in their financial status.
Which, if you look at what I just read, that is exactly what is meant not to happen. It would be manifestly contrary to the objectives of those who created the Constitution to permit the United States to exercise power under an international agreement.
I get that.
And that's what that
Hello,
was.
people. We're going to go back to that in just a minute. I just wanted to remind you, you check all your corporate media this September 11th when they play video of the two towers coming down, and then ask yourself, where's the third building, the Solomon building, that collapsed with no plane hitting it? Ask yourself this question and call your local CBS, NBC, ABC station and say, hey, why don't you ever show the collapse of the third building at the World Trade Center? World Trade Center 7, the Solomon building, came down 6 hours later with no plane hitting it, and they won't talk about it. Back to Billy Renee Powers. Thanks for watching. William Wagener saluting you for getting an education you can't get on the corporate media.
Right to bring this cause of action privately. come on over here, Maneva. Maneva is...
This is Maneva.
She's the paralegal. She wrote she's a legal assistant who did all the legal work.
I just want to say that Judge Carter, he's a fair man. And what I heard him say is he's going to go in his chambers and make a decision as to whether he's going to rule for a Fourth Amendment amended complaint so that we can coordinate and consolidate the joinder with the other claims, or rule. So that's what we're waiting for. We're waiting to see if he's going to just go on and rule for the Fourth Amendment complaint, and that's in our favor.
It is, and he did say that. He made it very, and he did shake his head and say which he's inclined to do. That's in our favor.
So that tells me that he does understand. He summarized very well about congressional intent, and had the bank stuck to what the Title 12 and regulations guidelines were. These people of our United States of America would not be harmed right now. So he did summarize that very nicely.
He seemed to be very knowledgeable about the fact that we have brought what no one has brought before him. So with that said, I don't know about the rest of you, but when I've got something I've never had before me before, I've learned to stop, think, and before reacting,
and that's what he did.
Actually take time.
And that's what he did. Thank you.
Maneva, come back. I'm not done with you yet. Stay close.
Switch side. Switch
side. The judge is sitting on a case of what I would call first impression. I say that after going to law school for 3 years and gone to 1,000 cases in law in 40-some states. He's sitting on a case of what they call first impression. It's going to be historic. If he makes the right decision, all these bankers are going to be in trouble. But one thing he made clear, all this stuff about frivolous lawsuit, he told Renee and her attorney when she finally came in, forget about that. There isn't going to be any retaliation for frivolous. This is not frivolous.
Yes.
He made that clear. But he also said, and this is what disappointed me, he also said, and we're not going to be contacting the Justice Department to have any of you attorneys prosecuted for what you've done. And Faith Brashear, who's here in the audience, she spoke up. She couldn't keep quiet. But it looks like he was giving a little bit to both sides. But Judge Carter, if you ever get on YouTube and look at this, I'm telling you something. If you make the right decision,